One of my favorite scenes in sport is the start of the marathon, when hundreds of athletes are waiting for the starting pistol. They've trained for months, but they know that only one will cross the finish line first, the best. But to enable the best to win, rules must be equal and fair. In business, having the same set of rules for all firms, irrespective of their ownership, public or private, or nationality, domestic or foreign, is called competitive neutrality. It is extremely important not only for firms, but also for consumers, because the winning companies are those who are able to offer consumers the best products at the lowest price. The state lays down the rule for competition, but the state may have a dual role as a policymaker and market participant, typically through the so-called SOEs, state-owned enterprises. Governments may be tempted to grant SOEs a privileged market position through soft loans, subsidies, exemptions, or tax benefits, thus hindering the competitive process. In some cases, the state may have good reasons to grant exceptions to competitive neutrality, which is not an absolute principle. In particular, SOEs, or even private companies, may be granting exemptions to attain public policy objectives. However, these exceptions should be limited to what is strictly necessary for achieving the objectives. The public policy goals should be balanced against the loss of consumer welfare.
In the European Union, competitive neutrality is enshrined in the treaties. Article 160 FEU prohibits member states from granting special rights to public entities or firms if this infringes provisions on competition and free movement. However, it allows for exceptions for undertakings entrusted with services of general economic interest, provided that this is necessary for them to achieve their public service missions. Competitive neutrality is also safeguarded by the rules on state aid. Under Article 170 FEU, any state aid which distorts competition and affects trade is incompatible with the internal market, unless otherwise provided in the EU Treaties. Through the application of these provisions, the European Commission carries out its task of ensuring a competitive, well-functioning EU internal market.
What is the role for competition authorities in all this? Well, competition authorities may have a decisive role. They can promote competitive neutrality both through competition enforcement by tackling anti-competitive practices by SOEs and through competition advocacy by urging policymakers to choose the least competition restrictive options to achieve public policy objectives.
Competition agencies need to tackle anti-competitive behaviour by state-owned enterprises in the same way that they do with privately owned enterprises. This means they need to guard against abuse of dominance, particularly, for example, in recently liberalised sectors where the state-owned enterprise may still enjoy a dominant position. Similarly, just like private enterprises, SOEs may participate in cartels, they may launch anti-competitive acquisitions, and they may engage in restrictive vertical agreements. However, enforcing competition rules against SOEs presents enforcers with particular challenges. First, some jurisdictions simply exempt SOEs from competition law altogether. Secondly, even in the absence of exemptions, in some jurisdictions, SOEs may be able to avoid liability by claiming a state action defence, and essentially arguing that their allegedly anti-competitive conduct was imposed upon them by the state. In that case, obviously, it's important that there is very clear evidence to substantiate the case that the state forced them to do whatever it is that they're accused of doing. Finally, it's also important to recognise that SOEs are often not structured as profit-making entities, and this can complicate the sorts of standard analysis that we often run to understand whether an enterprise's actions are anti-competitive or not.
legislation may result in distortions of competitive neutrality, especially in those jurisdictions without a state aid framework. For example, regulations may grant subsidies only to specific firms, typically state-owned enterprises, or may limit access to the market by new entrants. Legislation may also entrust public services in a discretionary way. In all these cases, competition authorities can foster competitive neutrality using advocacy powers. Competition authorities can also promote privatisation or liberalisation reforms, typically in cooperation with sectoral regulators or ministries. For example, competition authorities can advocate against the risk that privatization results in the transfer of undue advantages from the state-owned enterprise to the private acquirer of those assets. In the context of liberalization and newly liberalized markets, competition authorities may also intervene whenever the rules imposed on new entrants are considered more burdensome than the rules that are imposed on the incumbent.
We can expect that the COVID-19 crisis will further increase the relevance of SOEs as a result of state interventions to support the economy and stimulate growth. Then it will be for competition authorities to advocate for industrial policies that focus on pro-competitive solutions and ensure that state aid is provided in a transparent way and for a limited period. If those efforts are successful, competition authorities will foster competitive markets and a quick, vigorous economic recovery.